Thank you, Mr. Westwood. And Mr. McHale, do we have you on the line?
Yes. Good morning, Your Honor. George McHale, defendant appearing pro se.
Morning to you, sir. All right. So just so that the record is clear, the plaintiff did file an appeal from arbitration. That was on June 17th, just last month. And we are here today to set a trial on the initial complaint. Have the parties had a chance to speak about how much trial time they think they would need and how soon we'll be ready to bring this trial on? Mr. Westwood?
Yeah, we need no more than an hour to present our case. As far as timing for the actual setting of the trial, I have a motion for summary judgment I'd like to get filed. So if we could set it with enough time for me to get that motion filed in the next 2 weeks and have that ruled on, that may deal with the case through that motion. So maybe we could look at a date that would work for that.
All right, let's talk about that schedule first, and then we'll talk about the trial date to follow. If you're telling me, Mr. Westwood, that you can get this motion done in the next 2 weeks, that would put us on Wednesday, August 12th. If that was the filing date, then Mr. McHale, your response would be due 1, 2, 3, 4, roughly September 11th, and then reply roughly September 25th. If oral argument is set, that probably would be maybe the second week of October. I'm pretty quick on my rulings. I'm guessing I'd have a ruling to you by probably 2 weeks later, October 23rd. I think, gentlemen, the way things are shaping out, we can probably look for a trial date in early to mid-November, but we would have to fit a final trial management conference in there somewhere, and I need to leave enough time for that. So, Mr. McHale, how does that work for your schedule?
No objection, Your Honor. Plaintiff can file on his timeline, and defendant will respond within the time provided.
Okay. And then as far as the type of trial, are we going to try this case to a jury, or have the parties agreed that this will be a bench trial? If it's only an hour on the plaintiff's side, it's not a whole lot of time, but this really is up to the two of you. Mr. Westwood, what were you thinking?
Yeah, we prefer a bench trial. I don't know what Mr. McHale would like to do. But...
And Mr. McHale, I don't want to make any assumptions. A bench trial is a trial to the court, meaning I, as the judge, would hear the evidence, make the findings of fact, and then applying the law to those findings, reach a verdict. Obviously, a jury trial would be just as it sounds.
Understood. Defendant's agreeable to a bench trial, Your Honor.
Okay, so I think we can probably set a single day, and that should give us sufficient time. And that will, I think, help with the timing of the final trial management conference, because I don't typically need as much time with a bench trial as I do with a jury trial. So let me speak to my staff about finding everyone a date for the trial. Mikkel, let's look, as I said, maybe the second, well, let's see. Boy, the trials are really piling up, aren't they? All right, Mikkel, I want you to start in the second week of November and give me our first available, although it looks like, gentlemen, it does look like we're set for a fairly lengthy medical malpractice case starting on the 16th. That's a tough one to schedule around, but we can try.
We are scheduled a lot of trials in the month of November, but we could probably put you on the schedule for November 9th.
Okay.
That works for us.
So that would be Monday, November 9th, starting at 9:30. How's that for you, Mr. McHale?
Let me just look at my calendar real quick, Your Honor.
Yes, of course.
If there's anything later in November, I may be traveling on the 9th, and I just want to make sure that I'm here.
We can
There's
check,
any-
Mikkel. Yeah, like I said, the only sticky part is that medical malpractice trial that we have, but I can work with you. Mikkel, what can we offer next?
We might have to look into December if that's okay.
Yeah, maybe the 9th or 10th. I see those are open at least for trial.
We can do the 9th.
You know
at
what?
All right, gentlemen,
9:30.
we're
know
now
what?
looking at December 9th, starting at 9:30.
You know what? I'll make November 9th work. Let's just take
Are you
that.
sure?
Yeah, let's make it easier.
Okay. All right. Okay. So, Claire, we need to show in the minute entry an order setting this matter for a trial to the court on November 9th, 2026, starting at 9:30. Gentlemen, we'll block the entire day, and if we finish early, fine, but if you need more time, I'll make sure that you have it. And then, Mikkel, we'll need to get the final trial management conference on the schedule, maybe 2 or so weeks in advance.
It may have to be 3 weeks in advance because we are dark in that 2 weeks before, but we can do the October 19th at 8:30 or 8:45, sorry.
October 19th, 8:45. How's that for everybody?
That works for us.
Yeah, that works for me as well, Your Honor.
Okay. So Claire, next order, setting this matter for a final trial management conference on October 19th. That is a Monday, and that will be at 8:45. That will be a virtual conference. And Mr. McKay, again, I don't make any assumptions. We'll give both parties detailed instructions as to the court's expectations for that trial management conference, and it should be pretty clear.
Okay.
Okay, so the last thing I want to do is come back to the potential motion for summary judgment, and I do want to set a deadline for that, Mr. Westwood. Are you okay if I set that deadline as Wednesday, August 12th?
Yeah, that sounds great. I can get it filed
Okay.
by then.
All right. Yeah, just want to make sure that we get everything done in advance of the trial date. So Claire will show a further order directing the parties that any motions for summary judgment shall be filed not later than Wednesday, August 12th, 2026. Okay, I think that covers everything, but Mr. Westwood, was there anything else on behalf of your client?
Yeah, just one thing, and you can let me know. We have our witness that I would like to be able to have him or her appear virtually. Do I need to do that through written motion or?
Yeah, typically that would be a written motion. If the parties are able to stipulate, fine. If not, then just get that filed with enough time left for Mr. McHale to respond and we'd have time to rule.
Okay.
All right. Generally speaking, I don't push back too hard on these types of virtual appearances, but I will want to know the full circumstances.
Okay.
All right. Anything else, Mr. Westwood?
Nothing for us.
Mr. McHale, how about on your behalf?
I just want to understand the deadline for submitting the list of witnesses, Your Honor.
Right. So that will be in the joint pretrial statement, which will be filed in advance of the final trial management conference. So you'll see all of those dates and deadlines in that minute entry that we issue today.
Understood. Yeah, I have no further questions then, Your Honor.
Okay. All right. Thank you, gentlemen. If you need me, feel free to reach out directly to the division. But otherwise, I'll see what comes in a couple of weeks, and we'll go from there.
Thank
Great.
you.
Thank you so much.
For now, we
Appreciate
are
it.
adjourned. Thank you all.
Take care. Bye-bye.
Hello.
Hi, this is Mikael Judge Martin CA. We'll start in about 5 minutes, but I will check in just to make sure we have everybody before then.
Excellent.
Hey, Ben.
Hey, Bob, how are you?
Good. Didn't know you were still with us, brother.
Yeah, I'm trying to figure out what's going on to get in the interim. I guess I still am.
Okay. Hi, Andy. Andy, I think you might be
He froze.
either froze or muted. Hi, Scott.
How are you doing?
Yeah, another day in Eastern Paradise. I'm ready
Andy's
for lunch.
talking, but we're not hearing him, so he's got to figure out his audio.
It's your motion, Andy. You better get the voice down.
Can you guys hear me now?
We can hear you.
Yep.
Good morning.
Good morning,
Hey,
council.
Andy.
This is Mikael Judge Martin CA. We're going to start in about a minute, but do we have everybody to start this hearing?
I believe we do.
All right, sounds good. Then I will let Judge know that we're ready to go as soon as 9 o'clock hits.
Thank you.
Good morning, everyone. Nice to see you all. Can everyone hear me okay?
Yes, Your Honor.
All right, good. Nice to see you again. Let me call the case. This is the time set for oral argument on a motion for partial summary judgment. This was filed a while ago. It was December 9th, 2025 in CV 2021-052096. The plaintiff in that case is Anthony Lamka. The moving party is Police Construction, Inc. There are several other defendants. Let me begin with appearances, starting with counsel for the plaintiff.
Good morning,
Ben
Your Honor.
Jensic.
This is,
Oh.
go ahead, Ben.
Oh, Ben Jensic, local counsel for plaintiff Lamka.
All right,
And
thank you, Mr. Jemsick.
This is Bob Sokolov on behalf of the plaintiff, and I will be arguing today, Your Honor.
Nice to see you, Mr. Sokolov.
Thank you.
And then, Mr. Peshek, would you like to announce on behalf of your client?
Yeah, Police Construction, Your Honor.
All right, and then, let's see, it looks like we've got Mr. Anderson, and I know you represent the city, just listening in today,
That is correct, Your Honor. Thank you.
and that's perfectly fine. Okay. So just so that the record is clear, again, the motion for partial summary judgment filed back on December 9th, 2025. There was a response filed on March 20th. There was a little time taken for some additional discovery, but the reply was filed on July 1st, 2026. This is a statute of limitations argument on the personal injury claim on behalf of Ms. Lamka. And counsel, I have read carefully the briefs. They were very good. Thank you for that. And I did take the time to go back and review the entire case. So I'm fairly well up to speed. And I'm going to give both sides a full opportunity to argue their cases. But counsel, just so you know, and I think you probably already know this about me, I may interrupt with questions. That's no disrespect to you. Just want to make sure that if there are matters that the court is unclear about, which as of right now there aren't, that I'm able to get those straightened up before the hearing concludes. So with that, any preliminary matters, Mr. Peshek?
Thank you, Your Honor.
All right, Mr. Sokolov,
Yes, Your Honor.
any preliminary matters?
No, sir.
Okay.
No, sir.
All right, we'll start with the moving party. Mr. Peshek, that's you.
Thank you. Well, I'm sorry you had to go through the entire file on this thing. It's a long
It's all right.
tortured history. So when plaintiff amended their complaint, they did allege new counts against the city of Phoenix and then new damages against both the city of Phoenix and police. And city of Phoenix originally filed their motion for summary judgment based on both the statute of limitations, which they had a 1-year statute, and we had a 2-year, as well as a failure to do a notice of claim. And their motion was granted based on the notice of claim. And so my pending motion is purely on the statute of limitations because I don't have that same argument of them. The big issue that we have in this particular case is what is the accrual date? And I think what we will establish, what I will argue is we don't know a date certain for the accrual, like many cases, especially when you get into toxic mold, personal injury cases. But what we have is a quote, no later than, end quote, date. And what I will argue, and what I believe the record shows, is there is a no later than August 2022. Whether the accrual happened in 2020 when the event happened, we don't know, or 2021, but we know as of August 2, 2022, that is the date that we know for certain that the claims have been made, that the symptoms have been found by Ms. Lamka. One of the things that I do want to point out, and I didn't put in our moving papers, is the burden of proof. And when you're talking about the burden of proof in a discovery rule case, Whitcop talks about the plaintiff has the burden of establishing that the discovery rule should be applied to delay the statute of limitations. The burden is not on the defendants, and Whitcop relies upon the longer quest that states once a defendant has established a prima facie case entitling them to summary judgment, the plaintiff has the burden of showing available competent evidence that would justify a trial. And in fact, what happens in the conclusion of Whitcop is a Court of Appeal states, accordingly, when viewed in the light most favorable to Whitcop, the record does not support a delaying of the statute of limitations. So therefore, in this particular case, once an accrual date is set, the burden is upon the plaintiff, not us, to continue that date, which is unusual in most motions for summary judgment. I don't think the facts are in dispute as to pertinent dates. We know that loss happened in 2020. We know in June 2022, the plaintiffs received reports indicating that there was various types of molds in their home. We know in June 2022 that they were told that the molds that were found were quote unquote toxic. And we know in August 2nd, 2022, that Ms. Lamka went to a medical provider for the sole belief that she believed that she was suffering symptoms consistent with mold exposure. Plaintiff talks about, exploring that, and there was not that many records, and I tried to isolate the records from in August 2022 on her health, as well as a later one from Mayo in August of 2022. But it states specifically the reason for the visit is a contract with and suspected exposure to mold. That is what she reported to the medical provider. She reported coughing, wheezing, breathing, fatigue, phlegm. She reports that the types of molds that were actually found in her house, and those are the molds that later in 2025 she was actually found to have within her blood system when finally tested. The doctor actually recommended that she move out of her house. And not only that, but the Lamka specifically requested the medical provider write a letter. I don't know whether it was submitted to insurance or otherwise, to specifically state that Ms. Lamka should move out of her house due to the health concerns and should not move back in until the mold is remediated. It's unusual to have a doctor write that letter. That letter was written for a particular purpose. A doctor normally will not write a letter unless there's a specific belief that they were exposed to mold. Plaintiff argues that and it is important to note when she goes to Dr. Patel, which plaintiff provided some of the records in 2025, her chief complaint in 2025 was evaluation of a chronic cough and breathing. It's the same complaints and same symptoms that she complained of in August of 2022. Plaintiff argues that she was under the belief that it's not related to mold. Well, if so, why would they ask for a letter from their doctor to say that to provide to either insurance or otherwise to say that they should be moving out of their house and not move back in? And 3 weeks later, if they didn't believe that it was related to mold, why did they ask for an appointment with Mayo, where the Mayo appointment that we submitted was seeking an appointment for exposure to mold? She was under the belief after August 2022 that she had the exposure. That's why she asked for a follow-up visit. That's why she asked for a letter from her provider. The plaintiff talks about the discovery rule, and they rely upon Walk versus Ring, which is a 2002 case that does deal with the discovery rule, and we do agree that that is good law today. However, that doesn't discuss toxic mold. Whitcoff, that was decided in 2013, 11 years later, said it was a case of first impression, that Arizona cases had not considered what the discovery rule in terms of personal injury claims related to toxic mold. The court in Whitcoff looked at cases from across the country and came up with a 3-part test that we put in our motion. The claimant experienced physical signs and symptoms, knows that she's been exposed to mold, and knows that mold may be present as a health hazard. The element 2 and 3 are non-disputed. As of June 2022, she was told what mold was in her home and that she was told that it was toxic. The question is, did she experience physical signs and symptoms of the illness, and did those accrue, as we believe, by August 2nd, 2022? The court in
Counsel, if I may,
Whitcoff,
I'm sorry, is it
Yes.
August 2nd or August 22nd?
2nd, Your Honor.
2nd, okay, thank you. Please
So
continue.
the Court of Appeals looked at various cases around the country, and they stated that they found the case of Gerke versus Romero particularly intrusive, which was not an Arizona case, in order to try to determine how do we deal with the discovery rule with personal injury claims. In the Gerke matter, the case is very similar to this, that the plaintiff was suffering symptoms that they believed to be related to mold, knew mold was in the house, and they believed that the mold was causing symptoms, even though they were not diagnosed with a mold finding by any medical provider for 3 years later. The accrual happened when they believed that they were exposed to the mold. Similarly, in Whitcoff, the plaintiff Whitcoff was experiencing physical symptoms, was aware of the presence of mold, knew mold was dangerous, and suspected mold could be the cause of the illness. There was, again, no diagnosis that that she was, by any medical provider, that she was suffering health effects. She had gone to a couple different medical providers and was not diagnosed, but she had reported that she believed the symptoms were related to mold. Based on her belief in that case, even without a diagnosis from a medical provider, the court concluded that the lower court's granting of summary judgment was proper. And the court did take up the fact that she was not formally diagnosed. And what the court, I'm sorry, did you say something, Your Honor?
I did not.
Oh, I'm
Please
sorry.
continue.
I thought that's somebody said. The court said, even though went to other providers, none specifically stated that she was not suffering from any mold exposure. They said if that was the case, maybe we could consider that argument. In this particular case, what we have is she went to a medical provider in August 2022, who specifically told her, do not go back and live in the house until it's remediated because of the concerns over the mold. She was never told that that mold was not a potential cause of her symptoms. The plaintiff argues that she believed it to be asthma, but there is nothing in any record from any medical provider in 2022 that says you do not have mold-related conditions. So what we believe that evidence is that there is a notice was no later than August 2022, and the amended complaint was filed in 2025. And based on the Witkoff case, the burden on the plaintiff is to extend the discovery rule beyond the date that she believed that she had mold-related symptoms, because the test of Witkoff is that you have a belief, not that you are medically diagnosed with mold, as they're claiming that it should be based on Dr. Patel in 2025. Normally, we would be seeking summary judgment for a particular count or something. In this case, it's a little bit unusual. When they filed the amended complaint in 2025, they added 2 new counts against the city of Phoenix, which was a trespass and a nuisance claim. The only thing that they changed in relation to my client, Police Construction, was to add an additional damage category, which was a personal injury. And so we normally would be seeking to dismiss count 1 or count 2. But in this particular case, negligence was the only count alleged against my client from day 1. So we're seeking partial summary judgment as to the damage for personal injury only, because the remainder of the negligence claim in relation to the damage to the property, we are not arguing is subject to the statute of limitations. And with that, I will stop unless you have particular questions, Your Honor.
No, that was helpful. Thank you, Mr. Peshek. Mr. Sokolov.
Yes, Your Honor.
Witkoff does not require a specific mold diagnosis. Isn't that accurate?
Yes, Your Honor, but I'd like to address that as